Well, hello, everyone. This is Mark Elliott, Chair of the Litigation Department with Phillips, Nizer in New York. And today's topic is antitrust. Many of you probably already know something about antitrust law and anti-competition law, but let's give a little bit of an overview. Primarily, antitrust law is about protecting competition. It's about protecting the free market and ensuring a fair and level playing field in the marketplace. The ultimate policy goal of antitrust law is to have the marketplace produce the best quality of goods and services at the lowest possible prices. Antitrust law and anti-competition law prohibit or otherwise address a lot of different types of conduct, but primarily it focuses on prohibiting price fixing among competitors or other illegal collaboration among competitors, such as dividing the marketplace. And an illegal division of the marketplace could look something like two competitors divide up the marketplace by geography or by industry type. One competitor says, I'll sell my widgets to the auto industry. Another competitor says, well, I'll sell my widgets to the appliance industry, and we won't overlap. That's absolutely illegal. Competitors also may try to divide up the marketplace by specific customer lists. Again, illegal. Now, why did I choose this topic? I chose this topic because it's very important for our clients, and it's a very important service that all of us can offer our clients if you have the expertise. And there are at least three reasons why this topic was chosen. First of all, and very importantly, it can apply to nearly any conceivable client, whether it's to one of the largest corporations in the world or a more local or mid-market or even small client. They could engage in conduct that could land them in hot water as a matter of antitrust law. So almost any client could have an antitrust issue. Number two, the consequences in the United States, the European Union, and elsewhere of an antitrust violation of the highest order, such as price fixing and other things of that ilk. The consequences are very severe. What's the third reason? Our clients need us. This is a very complex area of law, and even on some of the areas that may seem very clear-cut, our clients and would-be clients need our guidance. So let's break that down a little bit. First of all, virtually all countries have some sort of antitrust law or what's also called anti-competition law that outlaws price fixing, market division, also addresses things like monopolization. So as I indicated, nearly any business could find itself having to address an antitrust situation. The consequences, our second reason for having this program. The consequences are very severe in most countries. In the United States, just by way of example, a violation of the antitrust laws, the serious laws for price fixing and the like, up to 10 years in prison, up to $1 million fine per individual per violation, and $100 million fine per violation for a corporation. I do a lot of antitrust seminars, and we'll talk about that in a moment, to clients and the like, and oftentimes they don't really want to be sitting there. They want to be making money doing other things. Understandable. But when you talk about jail time and $1 million fines, let me tell you something. Your client's going to put their iPhone down and give you their rapt attention. On the EU front, as you probably know, the EU fined Google $2.4 million, and only in the last few weeks has brought a substantial action against Amazon. On the civil front in the United States, there's, of course, monetary damages and a lawsuit that's brought by someone who is a victim of price fixing. And in fact, not only monetary damages, but something called treble damages, which just simply means they triple the actual damages. Of course, there's also the cost of litigation. Antitrust cases are extremely expensive, very document intensive, very complex. Last but not least for our clients, there's reputational harm. If your client is even accused, even wrongly, of price fixing or another serious violation, it's going to hurt their business. Another point I wish to point out is each country has its own antitrust laws, but the antitrust laws of the United States can have a broad international reach. So let's say there's a price fixing conspiracy and it comes out of Europe and the meetings occur in Europe, but they sell product into the United States and has a substantial impact on our economy, those clients can be hauled before our courts, and they may also be held responsible in the courts of Europe or other places. As I indicated, the third reason for this topic is our clients need us. Well, first of all, we talked about the stakes. Any area of law where a violation could land someone in jail or with $100 million fine for a corporation or $1 million per person, they need legal counsel. Now, some of these areas you may say to yourself, oh, come on, Mark, it's pretty clear cut. Our clients know not to fix prices. Well, first of all, they need to be reminded of that. Secondly, there's a lot of nuances involved there. So for example, your client may go to trade shows on a regular basis. When you're at a trade show, who do you see there? Your competitors. Conversations ensue, maybe very casual conversations at the hotel, bar, or restaurant. Well, your clients need to know that they have to be very careful about what they discuss with their competitors. Because even though a violation of the antitrust law requires an actual agreement to fix prices, they could find themselves subject to a government investigation or a lawsuit if there's a suspicion of price fixing. And once you start talking about prices with your competitors, all of a sudden you could be giving rise to that suspicion. So even on the clear-cut violations, they need your guidance. There are many areas of antitrust law, too many to cover in this short period of time, that are more nuanced. Things like vertical price fixing arrangements, exclusive territories, which can be perfectly legal, but they're governed in the United States by what's called the rule of reason. That's a very complex analysis. Your client should not be performing that without your help. So, what sort of guidance can you provide to your clients? Well, it can come in a number of different forms. The first thing I want to talk to you about is an antitrust compliance program. Almost any of your clients who sell product or deliver services for that matter would benefit from having an antitrust compliance program. What would the program entail? Well, first and foremost, it means sensitizing your client at the highest level to these issues. If you don't have top-down buy-in, the so-called tone at the top, the compliance program won't work. The program should include, after getting your buy-in from the so-called C-suite, an antitrust manual. I'm sure many of your clients, most of our firms have an employee handbook. But one of the things that should be in an employee handbook for many of our clients should be a section on antitrust law. At least for the United States, I have examples, be happy to share, but I'm sure we can get some from the EU, Latin America, and elsewhere. So you've got the program that includes the manual, includes the meeting with the top. It also should include interviews with the people at the top, not only to set the tone, but to ask them about their business model and to determine, much like a doctor doing a physical, is there anything about this business model that needs to be tweaked or followed up on because it might have an antitrust implication? You also should be meeting with people on the front lines, not just the CEO, not just the general counsel, but at least sampling of the representatives and the key salespeople, the people that actually interface with customers and interface with competitors. By the way, this is also a great way to know your client. As many of you already know from your own successes and attempts, if you want repeat business from a small client to the biggest client, you need to know their business and know their industry. Antitrust law and this compliance program is a backstage pass to your client to learn more about the intricacies of their business. And by the way, when it comes to doing, the other thing I want to talk about is doing a seminar to your client. And that you might even offer as gratis, for free, because it gets your foot in the door, you impress them, and you sensitize them to this issue, which hopefully will lead to you doing a more full-scale compliance program. Now, the seminar itself, you're not going to walk away from that seminar knowing that your client knows everything they need to know. Far from it. But what you will have done is sensitize them to know that they need you and to know that there's certain issues that they have to contact you about. What else can you do for your client? Well, consult with them on specific transactions or specific business models. Your client is thinking of entering into a joint venture with a competitor. Can that be legal? Absolutely. Should they be doing that without a lawyer's help? Absolutely not. Or they're entering into a new line of business, or they're changing their business model in a material way, they should consult with your firm if you have antitrust counsel, or help them find antitrust counsel if you don't, to guide them to make sure that their new business model or product line in no way poses any material antitrust risk to them. Last but not least, actual litigations and the like. Now, obviously, our goal for our client is to keep them out of trouble. But despite your best efforts, they still may find themselves sued under the antitrust law or the subject of a government investigation. And last but not least, and it happens more frequently, your client may get a subpoena, even though your client is not being accused of any wrongdoing, may get a subpoena in either a civil lawsuit or a government investigation, but they're going to need your help, both as to the proper scope of responding to that subpoena, but also to make sure that your client is in no way the object of any investigation or lawsuit, and you can protect them as best you can. So this is, to sum it up, it's an area of law that impacts nearly any client you could have, certainly any business, has very severe consequences, and your clients need you. Thank you very much.